Good evening, Section Z. I'm going to propose tonight that maybe we should think about changing our name to Section Zoom from here on out. So I'll just leave that with you to think about. Tonight we are going to talk about types of recording statutes and then some chain of title problems. And so we're starting on page 432 in the book. The effect of a recording statute depends on whether it is a race statute, a notice statute, or a race notice statute. So first of all, let's talk about the race statute. Basically here, the idea is that the first person to record their interest will win in a contest between two competing claims, even if the first person to record actually knew that there was somebody who had a prior unrecorded interest. So notice is irrelevant, it's just a race to the courthouse. This is the least common type of recording statute. The book tells us on page 32 about a very small number of places where they might have this for like mortgages or in North Carolina and Louisiana, but not used very often. One of the principal types of recording statutes is what's called a notice statute. And so this is a statute that gives priority to a bona fide purchaser for value if they did not have notice of a prior unrecorded instrument. So remember that recording statutes reverse the common law rule. Under the common law, if a person conveyed land to one person and that person was first in time, then the grantor was thought to no longer have any title that could be conveyed to another person. So the person who was first in time would win as between two competing claimants. But recording statutes are designed to create situations where the second person to receive an interest from the same grantor might prevail over the first person. And so in a notice statute, the conditions that allow the second in time, the subsequent purchaser, to prevail are if they took without notice of the prior unrecorded instrument, and if they paid value. They gave something financially valuable or economically valuable in exchange for their interest in the property. Now, what if you received your land by a gift rather than paying for it? Well, in that case, you cannot be a bona fide purchaser for value. You didn't pay any value; it was received as a gift, and so you are not protected by a recording statute, particularly a notice statute. About half of the states have notice statutes. The other principal type of recording statute is what's called a race notice statute, and here the person who is the subsequent purchaser has to prove the same things that you would have to prove under the notice statute. In other words, they have to prove that they were a bona fide purchaser who paid value, that they took without notice of the prior instrument, but they also have to prove one additional thing to prevail, and that is that they recorded first. They recorded before the prior instrument was recorded. So on page 434, problem 1, the authors give us a problem to kind of test out the basics of how these different types of statutes operate. Let me see if I can pull up a drawing of that problem. Here we go. All right, so here is the basic problem that is described in problem 1 on page 434. That O has interest in land. Let me see if I can get a pointer here. Okay. O has land and sells it to A, and that deed is not recorded at that time. Later, O sells the same land to B, who is a bona fide purchaser. He pays value, but the deed from O to B is not recorded when it is delivered. Later, A records the deed from O, and then turns around and sells the land to another purchaser, C, who is a bona fide purchaser for value. Then, after C has purchased from A, B records B's deed from O, and then after that, C records C's deed from A. And so the authors want to know who would prevail in either a notice jurisdiction or a race notice jurisdiction. So in the notice jurisdiction, let's imagine, first of all, that the contest was just between A and B, that C hadn't yet entered the picture. Well, A is first in time, but B argues under a notice statute that he should prevail over A even though he came second, because he meets the requirements for protection under a notice statute. So he is a bona fide purchaser for value. He paid value for the property. And he took without notice of A's deed. He didn't actually know about the deed that A got from O, and he didn't have constructive notice because that deed was not recorded. So if it was a contest between A and B, then B would prevail over A in a notice jurisdiction. But now, when A turns around and sells to C, we've brought another person into the picture. And so now the contest we're imagining is between C and B. And C says, I prevail over B. I am a bona fide purchaser for value. I paid value for the property. And I took without notice of B's prior interest. I didn't have actual notice of it. And I also didn't have constructive notice of it because B had not recorded the deed that he got from O. So in a notice jurisdiction on these facts, C would win. Now, what if instead we were in a race notice jurisdiction? Well, there, if we imagine a contest between A and B, B says, look, I was a bona fide purchaser. I took without notice of A's prior claim, but A says, well, but this is a race notice jurisdiction, and I recorded before you recorded. And so since even though you met the requirements to beat me in a notice jurisdiction, you didn't meet the requirements to beat me in a race notice jurisdiction because you did not record first. So if it were a contest between A and B, then A would win in a race notice jurisdiction. But the contest that we're thinking about now is between B and C. Those are the two people who potentially could now have claims to the land once C buys A's interest. C cannot claim priority as a bona fide purchaser under a race notice statute because even though he took without actual notice or record constructive notice of B's prior interest, he did not record before B. B recorded first. And so C would lose if his claim is, I am entitled to protection under the recording statute. But actually, in a race notice jurisdiction, C would win on these facts for a different reason. And it goes back to the fact that in a contest between A and B, A would win in the race notice jurisdiction. And since A beats B, the recording statute, or the law gives him the benefit of what is called the shelter rule. Since he is the prevailing party as between A and B, he has the right to sell his interest, and so he can sell it to C, and C can take A's interest and prevail over B by virtue of the shelter rule, which is described on page 432 of the book. So, all right. All right, now we're going to take a look at the second problem on page 432. So let me share that one for you. Here, we're told O is the owner of Blackacre, which is worth $50,000. And then he engages in 3 mortgage transactions where he borrows money from different people. So he borrows $10,000 from A, gives A mortgage on Blackacre, and that doesn't get recorded. He borrows $14,000 from B. B knows about the prior mortgage to A. B gets a mortgage and does record it. And then he borrows $5,000 from C. and give C a mortgage on Blackacre, and C doesn't know about A's mortgage, but C records. So let me show you this one kind of on a whiteboard here. So here O has the first mortgage to A that is not recorded. He has the second mortgage to B, who has actual notice of A's mortgage, and B does record. Then the third mortgage to C, who does not have any notice of A's mortgage, and C does record. So going back to the problem. Let's see. Sorry. The authors tell us that subsequently Blackacre is discovered to be contaminated with hazardous wastes, and its value plummets, and O defaults. And so upon foreclosure sale, Blackacre sells for $20,000. How should this amount be distributed among A, B, and C? And then they'll have a second one where they imagine that everything except the original value is $5,000. It says the dissenting opinion of Dixon in Hogue versus Sayer, suggesting that the parties should be given their expectations as the starting point for discussion by most commentators. They also have a citation to Grant Gilmore, a piece that he wrote on security interest and personal property. And so we'll talk about both of those here. But let's go back to the whiteboard. So the first suggestion that was made, they said, is the opinion that says you should give each party their expectations. So how could we go about dividing $20,000 and give A, B, and C what they expected, or at least should have expected to get in that circumstance? Okay, so the first thing to recognize is that this is a hard case because it's a case of what's called circular priority. So if you think about a contest between A and B, who would win? Well, A would prevail over B because he is first in time, and because B has actual notice of A's prior claim, and so B cannot claim the advantage of a recording statute. He's not a bona fide purchaser for value without notice. He, in fact, has notice of A's claim. So in a contest between A and B, A wins. Then, in a contest between B and C, who should win? Well, in that contest, B should prevail over C because he is first in time, and C cannot claim to be a bona fide purchaser without notice because B has recorded. And so if C does a title search, he's going to have constructive notice of B's prior interest. So A beats B, B beats C, but what makes this hard is that C also would be entitled to prevail over A because C would be protected by a recording statute. Under a notice statute, C purchased without any actual or constructive notice of A's claim. And under a race notice statute, he also beat A to recording. And so under either a notice statute or a race notice statute, C prevails over A. So A beats B, B beats C, and C beats A. Now the land has been sold at a foreclosure sale for $20,000, but the total amount of outstanding claims is $29,000. So somebody is not going to walk away with their entire mortgage repaid. And so how do we decide how much to give to each one? And the opinion from the old case says, well, try to give each party their expectations. So let's think about that. What should C expect? Well, C, based on what C knows or believes to be the case, when he gives his mortgage to O, he believes that there is a prior mortgage in B for $14,000. Or even if he didn't actually know that, he ought to expect that because that's what the proper title search would have revealed. And so C should expect to be second in line, and he should expect somebody else to get paid $14,000 before C gets even a dollar. But since the pot turns out to be $20,000, then C should expect to get his $5,000 paid under that scenario. So C gets $5,000. B also expects to be second in line because he knows that A has a prior mortgage of $10,000. And so he should know that if the land sells for $20,000 at a foreclosure sale, that he's only going to get $10,000. And so if we give B his expectations, he'd get $10,000. And then A, his expectation should be that he didn't record, and so he could lose everything to somebody who comes along later. And so he doesn't get his whole $10,000, he only gets the $5,000 that remains after we have satisfied the expectations of C and B. So that's one way you could go about trying to resolve this case. Now, the Gilmore piece that was cited in the book said that if you look at the actual cases that involve circular priority, what they seem to do is that they reach the same distribution that you would get if A had contractually subordinated his claim to C. In other words, if you imagined that A had entered into an agreement with C that C would be paid before A, then that hypothetical agreement between A and C explains the outcome in the cases. So if we looked at it that way, we could start with A, who's first in time. We could set aside $10,000 from the $20,000 at the foreclosure sale, because that's the amount of A's claim. But since we are imagining that there is this hypothetical contractual subordination agreement that A has agreed to allow C to be paid first, then we would pay C $5,000 out of the $10,000 that is set aside for A, and A would get the other $5,000. And then after A's $10,000 has been satisfied, the other $10,000 goes to B. So notice that if the land sells for $20,000 at the foreclosure sale, under either the expectations analysis or Gilmore's hypothetical contractual subordination analysis, the amounts are the same. A gets $5,000, B gets $10,000, and C gets $5,000. But then they ask a second hypothetical in the book. So let me show you that again. Second hypothetical is, suppose that all of the figures in this problem except the original worth of $50,000 were $5,000. So all of the mortgages are $5,000, but at the end of the day, the land sells for $5,000 at the foreclosure sale. Now we've got to figure out which one of the three, A, B, or C, is going to get repaid their $5,000. And the thing to recognize here is that in this case, the two different ways of analyzing it reach different results. If we applied the expectations theory, then both C and B would be out of luck. Let me go back to the whiteboard and show you that. So if we applied this expectations theory, C expects to be second in line after a prior $5,000 mortgage we're hypothesizing in B. And so if only $5,000 comes in at the foreclosure sale, C should expect to get nothing. B should also expect to be second in line after a $5,000 prior mortgage in A. And so if only $5,000 comes in at the foreclosure sale, then B should expect to get nothing. So under an expectations theory, both B and C would expect to get nothing on these facts, and so the $5,000 would go to A. On the other hand, if we applied Grant's or Professor Gilmore's contractual subordination theory, then we hypothesize this contract between A and C, where A agrees to subordinate his claim to C. And so if we set aside the $5,000 from the sale to pay A's claim, which was the first in time, but then we imagine this hypothetical agreement between A and C that C gets paid first, then the $5,000 would go to C under that theory. All right. All right, now let's take a look at the Messersmith versus Smith case, which is on page 435 in your book. In Messersmith, you've got an aunt and her nephew, Caroline Messersmith and Frederick Messersmith, who own a piece of land. And in 1946, Caroline executes a quitclaim deed transferring her interest to her nephew, Frederick. So at that point, Frederick is the sole owner of the property, although Caroline still manages it for them. But that deed, the quitclaim deed from Caroline to Frederick, is not recorded at that time. It doesn't get recorded until after the other transactions that are at issue here. Now, a lot of the action in this case focuses on something that happens on May 7th of 1951. And on that day, Herbert Smith comes over to Caroline's house and convinces her to execute a deed that conveys half of the oil and gas and mineral rights in the land to Herbert Smith. There's a lot of debate about whether Caroline was defrauded or whatever, but the court doesn't buy that. And Smith says that a notary public came to the house and that the deed was acknowledged before the notary public. Caroline disagrees with that, but in any event, it turns out that doesn't matter because everybody agrees that that first deed that was executed by Caroline was destroyed. And the reason is because it had a kind of a technical error. It referred to Caroline and his heirs rather than Caroline and her heirs. And so what happens is Smith goes back to the house later on. He has now a deed that has been corrected to have her heirs in it. And he has Caroline execute that second deed. And then Smith says he took the deed to a notary public, to the same notary public who had appeared earlier. That notary public calls Caroline on the phone and gets her to acknowledge that the signature on the second deed is hers. And when she does, the notary public notarizes that signature. Then after that May 7th transaction, Smith turns around and executes a deed conveying half of the mineral rights to E.B. Seal, and that deed gets recorded later in May. So this is an action by Frederick, the nephew, who is the true owner of the land after the transfer from Caroline. And Frederick is trying to quiet title to the property. He wants to establish that he owns it and that Smith and Seal don't have any interest in the property. So Frederick's argument is, look, Caroline deeded the property to me. I own it. And Caroline didn't have anything to deed to you when she executed these deeds on May the 7th. Seal, on the other hand, argues that he prevails as a bona fide purchaser, that he paid value for his interest in the property, and that he's a bona fide purchaser without notice because Frederick's deed from Caroline was not recorded until later on. So the North Dakota Supreme Court looks at this claim and they say, well, the problem is that even though Smith had a deed from Caroline Messersmith that got recorded in the sense of it was entered upon the records, it was not properly acknowledged because the facts showed that Caroline Messersmith had not actually appeared in front of a notary public and acknowledged her signature on that second deed executed on May the 7th. And so since she did not acknowledge the deed properly before a notary public, it couldn't be recorded, and therefore seal cannot prevail under the recording statute as a bona fide purchaser. Now, notice note 2 on page 441. The authors ask this: would seal have lost in Messersmith if North Dakota had a notice statute rather than a race notice statute? And here, the authors point out that in a notice statute, the subsequent purchaser is protected even if they didn't record their instrument. And so in a notice jurisdiction, seal should have won because he didn't have to record in order to prevail over the prior unrecorded interest of Frederick.